Welcome to our new series on AI. Over the coming months, we'll explore the key challenges and opportunities within the rapidly evolving AI landscape. Today, we will focus on AI in the context of employment law. In particular, the ways we are seeing employees utilize AI to assist them with otherwise routine human resources matters, and in turn, what employers can do in response to this. My name is Alexandra Manfredi. I'm counsel in Reed Smith's New York office, and I specialize in labor and employment law. One trend we are seeing is employees utilizing AI tools like ChatGPT to assist them with their own personal human resources matters. For example, employees are increasingly using AI to help them with the following sorts of HR matters: reviewing non-disclosure agreements, employment agreements, and other pro forma documents, accommodation and leave requests for raises and bonuses, internal complaints, responses to performance management, including performance improvement plans, reviewing separation agreements, and negotiating severance. Now, how exactly are employees doing this? Basically, employees are inputting questions, requests, and/or relevant employer documents and information as prompts into AI tools like ChatGPT. This, in turn, generates their desired content, the so-called AI output. For example, for an accommodation or leave request, employees might be uploading relevant employer policies, identifying their location, explaining to the AI tool their medical need or condition, and asking the tool to prepare a request they can send to human resources. Employees can even upload the company's specific request form and ask AI to generate content that would allow them to fill out the specific fields of a request form. Another example would be an employee who believes she has been subject to sexual harassment and wants to submit a written complaint to human resources. This employee could use AI to upload the company's sexual harassment policy, identify the jurisdiction in which she's located, explain the factual background to ChatGPT, for instance, and ask it to prepare a complaint describing the incident and the ways she thinks it violated the policy and relevant law. Here, it's important to note that AI tools are ever evolving, and because they in part learn from the inputs they receive by their users, AI tools could even ask this employee follow-up questions and gather other relevant information like whether the employer conducts sexual harassment training, how often that training is conducted, and what that training consists of, which could actually show the employee another area of potential non-compliance. These are just two examples of the many ways employees can use AI in this context. The result of this use is that AI is essentially playing the role of a phantom plaintiff's attorney in these sorts of scenarios. This trend is resulting in more sophisticated employee requests and responses to otherwise routine HR matters. Because of this, now more than ever, employers have less room for error when navigating HR matters. In response to this trend, there are a few steps employers can take for them to be best prepared for more sophisticated requests and responses that might be assisted by AI tools. First, if they have not already, employers should implement strong AI policies detailing what can and cannot be done on AI, including what an employee may submit to it. For example, employees can be precluded from using, disclosing, or uploading confidential information and documents, trade secrets, and intellectual property. In addition, AI policies can and should require compliance with all other employer policies when using AI, including policies like information technology, computer use, and electronic communications policies. For example, if a performance improvement plan addresses confidential trade secret information as it's relevant to an employee's job duties, let's say they're working on a strategic project for a new product or new brand that hasn't hit market yet, and the employee wants help with responding to that performance improvement plan, and they then upload it to an AI tool, that would be a violation of this sort of AI policy because the plan itself, which has now been uploaded to the tool like ChatGPT, addresses company confidential and trade secret information. While AI policies cannot necessarily address or predict every situation, policies with parameters on use and consequences for abuse can help curtail employees from using AI in this type of way. Second, employers should ensure that supervisors in HR are routinely trained on topics such as accommodations, leave, performance management, and handling internal complaints. As part of this training, supervisors in HR should be well-versed in company policies, practices, and relevant workplace laws, and should be reminded to comply at all times when executing HR functions. It goes without saying that training is a generalized best practice. However, here, as we're seeing employee communications become more sophisticated due to the potential use of AI, it's critical that employers are strictly complying with the law and their own policies. Lastly, and perhaps most importantly, employers should use common sense. Supervisors in particular, and to a lesser extent, human resources business partners, should know their employees. If an email, a letter, or a request doesn't sound like the employee, seems a bit too sophisticated to have been prepared by the employee, or structured in a way that is somewhat atypical of how the employee normally writes or speaks, that communication should be escalated to human resources or legal. In such instances, it might be that the employee is using an AI tool, or it might be that they've retained counsel who might be ghostwriting their communications. Nothing precludes the employer from asking the employee if they've used AI or retained counsel to assist in their communications, though whether to inquire about this would be dependent on the facts and specific situation at hand. Thank you.